afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with a vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Industrial Court versus Labor Court, Understanding the Process, the Law, and the Recent Amendment to Protect Your Rights. My name is Aisha Rahim, the People in Chambers with Ma Wing Kwai and Associates, and I will be your moderator for today's session. Before we start today, let me introduce the firm and what we do. Ma Wing Kwai and Associates is a mid-sized law firm that was founded in 1985 by Dato' Ma Wing Kwai. Our able team today comprises of 28 lawyers and 35 support staff. Dato' Ma is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small-medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Our 5 practice groups include ASEAN-China Desk, Construction, Foreign Direct Investment, Real Estate, and Sports and Esports. Today's talk is part of our Ma Wing Kwai and Associates online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging network for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event that you require specific legal advice to your matter, please contact us for a complimentary legal consultation, details which will be given at the end of the talk. Now, please allow me to introduce our speaker for today. Our first speaker is Mr. Navin Joshua Solomon. He is a senior associate in our dispute resolution, employment, and industrial relations teams. He holds a Bachelor of Laws from Northern University, Newcastle, and he was admitted to the Malaysian Bar in 2017. He was involved in the area of employment disputes, in which he has dealt with dismissal cases, trade union disputes, collective agreement, and collective bargaining. He also has experience in general litigation, contractual disputes, joint divorce petitions, and debt recovery. Our next speaker is Kirtika Padmanabhan. She's an associate in our dispute resolution department. She holds first-class honors in Bachelor of Laws from the University of Leeds, United Kingdom, and she was called to the English Bar in 2021 and admitted to the High Court of Malaya in January 2023. Her area of practices include strata management, family and citizenship matters, employment law, and criminal defense. The talk points for today are jurisdiction of the Labor Court and the Industrial Court, the process of filing a claim in the Labor Court and the Industrial Court, the amendments to the Employment Act 1955 and Industrial Relations Act 1967, and the reported cases from the Industrial Court and the Labor Court. The first 3 points will be covered by Ms. Kirtika, and the last point will be covered by Ms. Naveen. I will now pass the time over to Kirtika.
Thank you, Aisha, for that lovely introduction of both Naveen and myself. Good afternoon, everyone, and thank you for joining us at our talk today. As previously informed by Aisha, I will be going over the first 3 points of our talk today, which is basically the jurisdiction of the Labour and Industrial Court, the process of filing a claim at the Industrial and Labour Court, and recent amendments to the Industrial Relations Act and the Employment Act. So I'm just going to start off with the first talk point, the jurisdiction of both the Labour Court and the Industrial Court. Quite understandably, there seems to be quite a bit of confusion surrounding what exactly the Labour Court is. And in reality, there isn't actually a Labour Court. It's actually proceedings that come before the Director General of Labour, and it's something that we colloquially refer to as the Labour Court. Essentially, these proceedings fall under the jurisdiction of the Labour Department of Malaysia, and these proceedings are governed by the provisions of the Employment Act 1955, which, as many of you would be familiar with, was recently amended. Interestingly, the individuals who can actually file proceedings or file a claim before the Director General of Labour are actually employees. Now, the term employee itself has been defined in the first schedule of the Employment Act, and I won't bore you with the numerous portions of the definition, but the main part of the definition, which is often referred to, is basically when an individual enters into a contract of service with another person. And the term contract of service basically means an agreement, whether oral or in writing, whether express or implied, where essentially one person is agreed to be employed by another, and basically that person acts as the other's employee, and would often include situations whereby, for example, there's an apprenticeship contract, etc. Now, interestingly, what types of complaints fall within the Labour Court's purview are basically disputes between an employee and an employer, especially in respect of wages or any other payments in cash. For example, situations whereby your employer is not paying you your monthly salary on time, situations whereby there has been unlawful deductions of your wages, non-payment of your wages, late payment of your wages, basically situations like that. So I'm just going to go over the jurisdiction of the Industrial Court now. The Industrial Court basically falls under the jurisdiction of what is known as the Industrial Relations Department of Malaysia. And contrary to the Labour Court, any disputes relating to the Industrial Court are usually governed by the provisions of the Industrial Relations Act. The Industrial Court has a wide jurisdiction, and the matters that are often dealt with by the Industrial Court have been listed on the slide and include situations such as when there is an unfair dismissal of a workman. Now, if you see, I've put the term workman here in quotes because that term workman is quite important, because usually when it comes to disputes in the Industrial Court, it is only a workman who is usually able to bring a claim in the Industrial Court. And the term workman itself has been defined in the Industrial Relations Act, and it usually includes an apprentice or a person employed by an employer under a contract of employment and works for either hire or reward, and basically is able to bring any proceedings, including an individual has been dismissed, discharged, retrenched, etc. The second type of claim that can be brought before an industrial court is basically trade disputes. involving situations whereby there's a trade union dispute and things like that. And similarly, for applications relating to collective agreements, one situation whereby there would be a collective agreement would be, for example, between a union and an organization, for example, such as a bank. And basically, there are other situations as well, including but not limited to applications by a party bound by an award to refer to the High Court. Okay, so now what I'm going to do is I'm going to briefly walk you through the process of filing a claim in the Labour Court versus filing a claim in the Industrial Court. The stage to bringing a claim in the Labour Court would obviously be filing a complaint with the Department of Labour. And once the complaint is filed, essentially the Labour Court officer will start the investigation process. As with every investigation process, there are essentially two possible results. One is where the complaint has no merit, following which there will be no further action taken. And the other is when the complaint actually has merit. And when the complaint does have a merit, it will be referred to what is known as a conciliation stage. Now, a conciliation stage is essentially, if you can think of it as a negotiation stage, whereby the employee and a representative from the employer will come together and sit down and try and settle the dispute between themselves. So if the conciliation process is successful, then the complaint obviously would end there. But if it's not successful, the case would then be referred to the Labour Court and trial dates would then be scheduled. Essentially, what a trial is whereby parties go before the court and each party is given an opportunity to put their case before the court. And before that is done, obviously, the Industrial Court would send a letter of summonses, which basically informs the complainant and the company when they have to attend trial. So during the trial process is when they would actually put their cases, and then the court will make a decision on the complaint, following which an order will be produced by the court. And in the event parties are not satisfied, either party who has a financial interest in the order, or rather whose financial interests are affected by the order, can then file an appeal to the High Court within 14 days from the date of the Labour Court order. And this provision for an appeal is provided for under Section 77 of the Employment Act 1950. Now, what if there's a situation whereby you have a Labour Court order, but either your employee or you as the complainant are having difficulties enforcing the order? Basically, if the other party fails to comply with the order. Basically, there is Section 75 of the Act, which basically provides that where there is such non-compliance, essentially the Director General needs to be informed, and the Director General will then refer this case. He will basically refer this case by sending a certified copy of the order to the Registrar of a Sessions Court or the Registrar of a First-Class Magistrates Court. Now, for context and understanding purposes, the Sessions Court and First-Class Magistrates Court are the lower courts in the civil court system. And so basically, when the Director General sends a certified copy of this order to the Sessions Court and the First-Class Magistrates Court, what happens is it's then recorded as a civil court order. So essentially, it would be as though the Sessions Court or the First-Class Magistrates Court, as the case may be, has produced the order themselves. So when that happens, essentially you as the person who's trying to enforce the order would then be able to take this order and enforce it in the same court. So one method of enforcement would be, for example, a judgment debtor summons, which is basically an application to summon the non-compliant party to disclose their assets and to basically go to the court and explain to the court how exactly they are going to comply with the order and make payment as the case may be. Another example of enforcement is garnishee proceedings, whereby, for example, if the bank accounts of the defaulting party, you can then make an application to the court for their bank accounts to be frozen until they settle the order. So that's just a few ways to enforce a labor court order. I'm now going to talk about how to file a claim in the industrial court. Now, the first step, similar to the labor court, would actually be filing a representation to the Director General, and then following which there is immediately the conciliation session. So this would be regardless of whether the claim has merits or not. It's an automatic conciliation process. And once you reach the conciliation process, which is again similar to the labor court, whereby parties sit down and try to negotiate. One very important thing to note about conciliation is that whilst the company can bring along a legal representative to represent themselves, the same is not necessarily true for an employee. So an employee wouldn't be able to bring a legal representative. An employee would show up by him or herself, as the case may be. So similar to with the labor court, there's one of two options. Either an amicable settlement is reached at this stage, or there is no settlement reached. Now, in the event that there is no settlement reached, the matter is automatically referred to the industrial court, and following which a case number will be generated. And once the case number has been generated, the matter, basically there will be a case mention. A case mention is basically just to inform court that to go before court, and it's often by way of e-mention, which is a messaging system whereby parties inform court whether they have filed any forms to be legally represented, and then the court would then give parties dates to file their cause papers. In this case, as you can see here, the cause papers include a statement of case, statement of reply, rejoinder. Now, these three cause papers are effectively each party putting their case forward before the court. So the statement of case would be the employee's case put forward in court. The statement of reply would be the company's reply to the statement of case. And then the rejoinder, if any, would be the individual's reply to the company's statement in reply. These bundle of documents referred to filed together with the statement of case. So for example, if there's any supporting documents, they are usually annexed to the statement of case and the statement in reply. Following these initial cause papers, parties would then need to file witness statements. Witness statements are basically when you have individuals who know what's going on and individuals who are relevant to the case, they put forward their evidence by way of a written statement. And then they would need to then, once trial has begun, as you can see here, trial is the next stage. Once trial has begun, each party would then get to call their respective witnesses. Once trial has been completed, an award is then issued by the industrial court. And similarly here, if parties are not satisfied, the appeal may be made to the High Court within 14 days from the industrial court order. One very important thing to note in this entire process is that this beginning part of filing a representation has to be done within 60 days from the last date of employment. This is very important because oftentimes we have people coming to us and they have exceeded that 60 days. It's something that's quite difficult to overcome unless you have a very good reason for not filing your representation soon enough. That's one very important thing to note in case you are thinking of filing a representation with the Director General. Now, the enforcement of an industrial court award is a little bit different to that of the labor court. So where there is non-compliance of an award, essentially what will happen is whichever party wants to enforce the award, they would need to file a new case in the industrial court by way of Form S. And Form S is provided for within Rule 24A of the Industrial Court Rules. So once a party has filed Form S, it will be treated as a completely new case, but obviously it would be one for non-compliance. So the industrial court, upon hearing the complainant, they will issue something that's known as a non-compliance order. And in this non-compliance order, there is one of three directions that the court may make. One is obviously to direct the defaulting party to comply with the award. The second is to direct the party to make restitution for contravening the award, which is basically telling the defaulting party that they need to pay up for not complying with the award, or they may set aside or vary the award in very certain special circumstances. So something to note here is that this variation is only done in very limited circumstances. In terms of non-compliance, once this non-compliance order has been issued by the court, still the defaulting party fails to comply with the award, that party could be fined not exceeding 50,000 ringgit or imprisonment not exceeding 1 year. And this non-compliance punishment is provided for under Section 53, subsection 3 of the Industrial Relations Act. Now, one very important thing to note regarding this non-compliance fine is that previously and prior to the 2020 amendments, this sum of 50,000 was actually much, much lower. It was only 10,000 ringgit. And with this increase in fine, we can see that the industrial court is taking non-compliance very seriously. And it's just something that parties need to be aware of when it comes to enforcement of an award. Okay, so I'm now going to talk about the amendments to the Employment Act and the Industrial Relations Act. And for the sake of brevity, I'm not going to go through all the amendments. I'm just going to go through the amendments that affect the scope of both the Industrial Court and the Labour Court. So when we're talking about the Labour Court, the key amendments that affect the scope of the Labour Court are basically two amendments. One is the scope of the definition of the word employee, and the other is the provision for employment where there is no contract of service. So pre-amendment, as I'm sure a lot of people are well aware, the term employee was defined as those making less than 2,000 ringgit a month, and regardless of pay, those who perform certain vocations, including manual labor. However, post-amendment, the Act applies to those employees who are defined as follows. And this would include basically anyone who has entered into an employment contract of service. And I previously explained what exactly a contract of service is. And except for certain provisions relating to public holidays, rest days, overtime payments, this applies to all employees, except for these provisions whereby it would only apply to employees earning 4,000 ringgit or lower. So as you can see with the recent amendments of the Employment Act, the scope of the word employee has been significantly expanded, which basically allows for a lot of people to bring a claim or to refer a complaint to the Labour Court. Now, the second amendment, when in relation to the Employment Act, is the provision for employment where there is no contract of service. Now, this is a very significant change because pre-amendment, if you were not deemed an employee in accordance with your contract, it would be very difficult for the Labour Court to find that you are actually an employee. However, post-amendment, Section 101C of the Employment Act provides that basically in the absence of a written contract of service, an employee would be deemed an employee if, for example, his manner of work is subject to the control or direction of another person. Basically, in a situation whereby your working hours, for example, the usual 9 to 5, is set by your boss. And so the hours of work are controlled by your boss. The manner of work, meaning the scope of your work, what type of work you do, what type of work you're not allowed to do, things like that is controlled by the employer. And certain other categories as well, including whereby payment is made at regular intervals. So for example, if you get a salary and for example, you are paid every month, then it's much more likely that you will be deemed an employee regardless of what in the event that there is no contract for the Labour Court to refer to. So I'm now just going to touch on the key amendments to the Industrial Relations Act. And very importantly, the amendment came into force on 1st February 2021. And a few of the key amendments affecting the scope of the Industrial Relations Act include referral of dismissal cases to the Industrial Court, the death of a workman, the court's discretion to determine the date of termination, and the time limit for filing an appeal. So in relation to referral of dismissal cases to the Industrial Court, prior to the 2020 amendment, the minister had a certain amount of discretion as to whether representations can and should be referred to the Industrial Court. So if you recall previously, I mentioned that after the conciliation process, if parties are not happy, and basically if no settlement has been reached, the matter can then directly be referred to the Industrial Court. So pre the 2020 amendments, this was not the case. Essentially, after conciliation, the employee's matter would then be referred to the minister, and the minister would essentially look at the case and see whether he believes that there are merits to the case. However, post-amendment, the situation has very much so changed. Post-amendment, the Director General of Industrial Relations would basically, it's an automatic mechanism. So once conciliation is unsuccessful, it's an automatic referral to the Industrial Court. Now, in the situation of a death of a workman, pre the 2020 amendments, for example, if a claim was brought by you as an individual and unfortunately you have an untimely death, your claim would stop there. It would not proceed any further. However, post the 2020 amendments, the Section 29 of the Industrial Relations Act provides that the Industrial Court may still continue with the claim. So in terms of what awards the Industrial Court can make, it's the usual award, i.e. awards in relation to back wages or compensation in lieu of reinstatement, because obviously in this scenario, reinstatement would not be possible as the workman has passed away. And this award would be remitted to the next of kin of the deceased workman. The next amendment is the court's discretion to determine the date of termination. So previously, the Industrial Court was not allowed to amend or to determine the date of dismissal when a matter was referred to the Industrial Court. And basically, whatever date that is stated in the ministerial reference, basically once the minister has referred the matter to the Industrial Court, whatever date is stated therein, it would follow. However, now that the situation is very much so different, Section 29DA of the Industrial Relations Act provides that the Industrial Court is vested with the power to determine the actual date of dismissal. So this would then allow the Industrial Court to determine dismissal in situations whereby the date is either disputed or incorrect. For example, if a workman is served with a notice of termination and his last date of or his termination date is, for example, the 1st of June, but he still continues to work until the 1st of July, regardless of what the termination letter states. Essentially, the court will look at the situation in a holistic manner and determine that the date is actually the 1st of July based on the conduct of parties. The last amendment that I'm going to touch on today is the time limit for filing an appeal. So previously, if you wanted to challenge an award made by the Industrial Court, this was done by way of reference to a high court, by way of a judicial review. Essentially, a judicial review is whereby the high court reviews the decision of the Industrial Court to see whether the Industrial Court has erred during any time, at any point when making the award. And this process was actually quite long because usually for the judicial review process, there are two stages involved. The first is the leave stage, and the second is the substantial reference itself. So during the leave stage, you would essentially apply to the High Court for permission for your case to be referred to the High Court. So if, for example, that permission stage, you fail at that permission stage, your appeal can no longer proceed. However, that process has since been amended, and now any party, either party, has 14 days from the date of the Industrial Court award to straight away file an appeal at the High Court. So it removes the in-between leave stage, and it makes the process a lot more streamlined. I will now hand over to Navi to discuss the reported cases in the industrial and in the Labour Court.
Thank you, Kirtika, for that insightful lesson for us regarding the amendments and also the process for the Industrial Court and the Labour Court. So I'll be taking over by sharing about the reported cases from the Industrial Court and also proceedings before the Director General of Labour, which is commonly known as the Labour Court. Okay. In the Industrial Court, as you heard from Kirtika, there are many headings that you can file a claim under. And one of the most common ones are retrenchment exercises, dismissals, direct dismissals due to retrenchment cases. In this particular case of Karthikesu, you can see the claimant was employed on 24th of January 2020 as a probationer. And later on in March, 2nd of March, he was then placed on medical leave from 2nd of March to 19th of March. As you all know, we are supposed to always communicate whatever leaves, whether it's unpaid, annual or medical leave. So this was also communicated to the company as well. Due to the MCO, he could not return back to the company. He was told to wait until further instructions from the company. Later on 25th of March, which is nearly 2 months later after he was working, he was called to the company for operational reasons and to have a meeting as well with the HR and the head of operations. When he was in the meeting, he was suddenly then handed a notice of termination. The reason for the termination that was given at that point in time was that because the company was undergoing organizational restructuring. And the interesting part is that his last day would be the very next day, which is on 26th of March, 2023. The claimant then took his letter of termination and filed a claim for unfair dismissal, as all of us would. The Industrial Court then held that the retrenchment of the claimant was definitely not exercised in good faith, as the company could not show any real or significant cost-cutting measures were put in place. The reason why these kind of cost-cutting measures should be put in place is to at least show, even though you did not fulfill the full cost-cutting measure, to show something was in fact attempted by the company. It would try to show that the company avoided the retrenchment exercise. So that is when the Industrial Court can actually intervene in a particular retrenchment exercise, when it can be shown by any evidence that the retrenchment exercise was capricious, without any reason, and actuated by victimization or unfair labor practice. The main thing to be shown for the claimant to succeed is that the retrenchment was actually carried out in malafide, bad faith. The Industrial Court also quoted the Code of Conduct of Industrial Harmony. The Code of Conduct of Industrial Harmony is an agreement signed between the Ministry of Human Resource, the Malaysian Employers Federation, and also the Malaysian Trade Union Congress. In this code, there are articles with regards to employment and also a particular article in relation to how retrenchment exercise should be carried out. Article 20 in particular outlines a few examples such as hiring freeze, a reduction in overtime work, a reduction in working hours, or even transfer to other departments. These are all spelled out in the article. However, the company did not refer to this, and the court highlighted this by virtue of Section 30 sub 5A, in which the court is provided the discretion to consider these kind of agreements outside of the Industrial Relations Act. And the claimant was awarded back wages. Even though he was a probationer, he was still awarded back wages and not compensation, as compensations are usually awarded to employees who have served at least 1 year in the company. So they get compensation in lieu of reinstatement, which is 1 month's salary for each completed year of service. The next case is also another form of case that the Industrial Court would entertain in relation to trade union and its members. Trade union and its members have various cases that can be filed in the Industrial Court. In this particular case, the claimant was a member of the trade union, which is the National Union of Bank Employees, and she had been a member since 1997. So she participated in trade union activities such as picketing and social media campaigns, In this picketing and social media campaigns, of course, words were used and the bank took them as defamatory and derogatory remarks. The bank thereafter issued a show cause letter to the claimant in respect of multiple allegations of misconduct arising from the social media campaigns and the picketing that were carried out by NUBE. The claimant replied to state that she had been merely carrying out her duties according to the laws in place, which is such as the Industrial Relations Act and also the Trade Unions Act. The claimant had always been exercising her duty and not in her personal capacity, but in a capacity as a trade union member and officer as well. The industrial court thereafter held that a distinction must be drawn between personal capacity and also duties carried out in relation to union activities. That is why it is important to distinguish these two, as the part where they are acting in personal capacity, that may be regarded as insolent behavior. That should not be tolerated by the employers. However, when they are carrying out merely trade union activities, this is where you need to handle it properly to find out if these conducts were actually made in bad faith. So the industrial court also in this particular case went on further to state that they took into account the immunity any member of any trade union enjoy pursuant to Section 22 sub 1 of the Trade Unions Act. In this particular section, the Trade Unions Act provides that all members, officials, or even the trade union itself cannot have any action be taken against them when the action is premised in tort. Therefore, defamation falls under tort and no action shall be entertained by any courts. The claimant's dismissal was held to be unjust. She was rewarded the back wages, compensation, bonus, everything she would have enjoyed if she had remained in employment. And further, the claimant was also reinstated despite the bank claiming that the relationship has broken down beyond repair. Next, we move to a case where a severance package was negotiated between the employee and also the employer. Negotiations took place between the parties. The claimant was a CEO and the company negotiated, and upon agreement by both parties, the claimant then tendered his resignation as the CEO. The company accepted the resignation, and part of the terms of the severance package was 6 months' salary in lieu of notice, full waiver of his child's tuition fees with MIS until the completion of the remaining academic term, and also they went to the extent of restructuring of the appellant's car ownership scheme in order to allow the respondent an additional 3 months to repay the car loan. The claimant, on the other hand, upon accepting the severance package, then initiated a claim in the industrial court for constructive dismissal, whereby he was constructively dismissed in the sense that there was a breach by the employer. The claimant was in fact successful in the industrial court and was awarded 381,720 in back wages. This is on top of the severance package that he even received. Upon failing in its appeal in the High Court, the company still not giving up, they proceeded to file an appeal to the Court of Appeal. The Court of Appeal at that point in time allowed the company's appeal, and they held that, this is the best part of it, that the employee could not have the best of both worlds, in the sense that they can't negotiate a severance package and then claim that they were constructively dismissed. If it was true that the employee was actually constructively dismissed, he should have left his employment and not negotiated or accepted any particular severance package. That is the true meaning of being constructively dismissed. So these are the type of cases that we can see in the industrial court. There are even more, but just to share in the sense of the common problems faced by employers and also employees. We then move to the cases before the Director General of Labor, also commonly known as the Labor Court. In this case of latent contractors, the workers in question were employed as train assistants and they were earning more than the statutory threshold. And this is before the amendment to the Employment Act. So now, at that point in time before the amendment, the threshold was 2,000 ringgit. However, the employees in this case earned 2,500. They lodged a complaint to the Labour Court for overtime payment under Section 60 sub A3 of the EA 1955. The issue that came before the court was whether they were in fact employees, as the threshold was capped at 2,000. The Assistant Director of Labour held that the workers were in fact employees within the definition and they were entitled to claim overtime. And the reason for this was, as agreed with the High Court when the company appealed to the High Court, that the employee in such cases would need to establish that they are engaged in manual labor or performing manual labor. In this case, the High Court held that the employees were actually successful as they were in fact performing manual labor duties, and therefore they are rightfully entitled to the claim of overtime payments. In now, post-amendment, you won't be having this problem as the cap has been lifted. And as long as you're in a contract of service, you will be deemed as an employee. Next, in the case of Agenda Vira, here the case is slightly different, whereby it can still be complained to the Director General of Labour. They were being paid below the minimum wage of 900 ringgit at that point in time. The minimum wage in between 2013 and 2014 was 900. However, these employees were receiving below. And what the employer had disputed and contended was that their salary was in fact more than 900 because it had to take into account allowance and commissions. So it was in fact exceeding the minimum wage. The Assistant Director of Labour did not share the opinion of the employer and then ruled that they were in fact employees and entitled to benefits under the Minimum Wages Order 2012. Further, he also went on to state that the minimum wage that should be given should not comprise of allowances and commission. Wages, as you see the interpretation and definition in the Employment Act, wages do not consist of allowance and commission. On appeal to the High Court also upheld the decision of the Assistant Director of Labour. Next, we go to our last case, just to provide you with some background as to the kind of cases that can be entertained by the Labour Court. This employee was employed not just as a pembantu rumah. She was not paid a full salary for almost 5 years. And she went on to file a claim in the Labour Office for non-payment of salary. Of course, she had no papers, as in the sense that no offer letters. Her claim was then not heard on the ground that the Assistant Director of Labour directed both parties to submit on a preliminary issue under a separate act and found that she did not have a work permit for the employee. Upon appeal by the employee, the pembantu rumah and also / pembantu kedai, under Section 77 sub 1, Justice Aziza Nawawi, as she was then, held that the Labour officer had wrongly decided on the issue of the legal permit and pronounced that he lacked the jurisdiction to inquire into the complaint without hearing the merits of the claim. And in doing so, he had clearly abandoned his jurisdiction. Justice Aziza had also gone on to say that it is in fact premature for the Labour officer to only consider the permit issue. So therefore, even the High Courts are encouraging Labour officers to actually go into the merits, because the Industrial Court and the Labour Courts are institutions or tribunals that were created not to follow or to strictly stand by the technical and legal. So therefore, the High Court had then ordered for the case to be remitted back to the Labour Court to be heard on its merits. These kind of cases are actually the main reason why the Labour Court and also Industrial Court have been introduced, in order to decide on these cases without taking full account of the law and also being a court of equity. So with that, I end my session and I'll pass it back to the moderator. Aisha.
Thank you, Naveen and Kritika, for your sharing. So now we'll move to the questions and answer session. So we have several questions from the audience. The first question is from Catherine Lee, and she asked, are interns considered employees or workmen? Kritika, would you like to answer this?
Sure. Thanks, Aisha. Ms. Catherine, just to inform you that even with the amendments to the Employment Act and the Industrial Relations Act, unfortunately, they have not included interns within the definition of employees and workmen. The only individuals actually included with the new amendments are apprentices, and unfortunately, interns do not fall within that category. I hope that answers your question.
Thank you, Kritika. So now we'll move to the second question. This is from Anonymous, and the person asks, in a letter offers, if the letter offer stated a KPI allowance, but employer never details the KPI in verbal and documents, and employee also never paid the KPI allowance, then which court can they complain?
Okay, so I'm going to answer this in two parts. I think the main part here, your question is whether they can go to the Labour Court to complain. Of course, as this was stated in your letter of offer, there is always an opportunity for you to go to the Labour Court and file a complaint. As you now know, salary is also not a matter. And the next part is that when you have these kind of vague terms in your employment contract, my advice is to always clarify with the employer, because the situation in the labor court can go two ways. There might be an issue of discretion on whether the employee actually satisfied it and deserve this particular amount. So that is why my advice would be at the outset itself, decide and at least voice it out to your employer to say that, okay, this is the allowance, this is the amount that I want. However, since the mistake has already been done, no issues, go to the labor court, file a complaint and ask why this allowance has not been paid when this allowance was in fact promised. It's just that the amount will be in dispute, and this is a matter for the lawyers to advocate and also for the labor court to decide based on case laws and precedents. Yes.
Okay, the next question is from Mr. Kumar, and he asks, can an employee earning 20,000 ringgit be entitled to file a complaint with the Director General of the Labor?
Yeah, I'll take this one. So if you're earning 20,000, now with the amendments, you can file a complaint to the Labor Court, which is the Director General of Labor. So that is why, you see, previously what happens is if you're earning 2,000 and above or 5,000 and above, you can't file a complaint if there's any issues regarding the terms in your letter of offer. But now with these amendments, employees can actually save money, and instead of going to the civil court for any dispute on your offer letter, you can straight away go to the Director General of Labor, which is the Labor Court, and file a complaint there. There are just certain provisions in the Employment Act, such as overtime payments and hours of work on rest day. They don't apply to employees receiving a salary of more than 4,000. So those kind of issues can be ironed out when you actually consult a legal professional. Then we can see which are the things that you can actually claim. But apart from 6 issues, like I said, overtime and some other things, any other things are applied across the board, regardless of the salary that is being earned by the employee.
Okay, thank you, Naveen. The next question is from Putri Nur Amalia, and she asks, does the action brought by the complainant to the Labor Court is subjected to the Limitation Act?
I think I'll take this question as well. This is actually an interesting question because I had this question as well when I was doing employment matters in the Labor Court. So there is no express provision provided in the Employment Act. If you have a look at it, there is nothing to say that the action should come only within these particular days, except for any termination in relation to misconducts. Those kind of complaints must be brought within 60 days. That is in the Industrial Court. But in relation to the Employment Act, what I have seen from precedents and also case laws, the limitation that the Labor Court is following is the civil limitation, which is 6 years from the particular breach of any employment contract. So it would be 6 years. That would be my answer, but not based on statute, but based on case laws and precedents. Yes.
Okay, we'll move on to the next question from Ms. Jennifer Wong. She asks, since there is a new amendment, are there any conciliation between the employer and the employee? Kritika, would you like to take this question?
Sure. So basically, in both the Industrial Court and the Labor Court, there is a conciliation process involved. And I actually spoke about this earlier when I showed you the diagram whereby conciliation is usually promoted at such an early stage so that essentially if amicable settlement is possible between parties, it not only saves both parties costs, but it also saves both the Labor Court and the Industrial Court time as well from having to decide on the matter.
Okay, thank you, Kritika. The next question is from Mr. Kumar again. He asks, if an employee is put on garden leave, are they entitled to prorated unutilized annual leave?
Okay, so if an employee is put on garden leave, are they entitled to prorated unutilized annual leave? Okay, I think I'll just clarify in relation to garden leave. When someone is put on garden leave, they are already being put on paid leave, and these are usually people who are about to exit the company or people who are subject to some investigations, internal investigations. In both situations, I would like to just highlight that the parties or the employee in question is actually already being paid. And annual leaves has always been solely subject to the discretion of the employer. There are companies who have clear policies in place to state that when you're leaving, you don't get to use your annual leave, you leave just like that. There are things on how it is applicable, or they will tell you to use it to a certain way. However, these are, again, like I said, it's always helpful to clarify these things of the utilization of annual leave and everything before you join the company, which is before you sign the letter of employment, because these kind of small doubts and browsers which you raise and you finally incorporate it into the letter of offer, you actually save not only your time, but also your money in the event that disputes arise. So yeah, they are, of course, they are entitled, but again, subject to the discretion of the company. Yeah.
Thank you, Naveen. So we'll move on to the next question. And Miss Jennifer also asked, so now there is no more labor court and we only have industrial court?
No, Miss Jennifer. I'll take this question, Aisha. Both actually exist simultaneously. The reason why there is two separate entities, if I can put it that way, is that the labor court often deals with disputes regarding wages. So where there is an underpayment of wages, unlawful deduction of your wages, non-payment or late payment of your wages. So that those types of matters are often referred to the labor court. In contrast, the industrial court usually deals with matters relating to dismissal. So this would involve situations where you have been unfairly dismissed, or in situations whereby you have been put in such a situation where your working conditions are no longer favorable to you, where you are forced to resign. Another situation that the industrial court deals with is trade union disputes, etc. So I hope I have answered your question.
Thank you, Kirtika. The next question, someone asked, how does the employee enforce the order by labor court to pay, say, outstanding wages by resorting to the employer's bank account?
I'll take this one as well, Aisha. So it's not so much resorting to the employer's bank account. There's actually a step, a clear process involved. Usually what happens is the Director General would refer the matter to the Sessions Court by essentially sending a certified copy to the Sessions Court or the First Class Magistrates Court. The registrar will then record it as that relevant court's order. And once that has happened, the registrar has recorded it as an order of its own court, of that own court, you can then enforce the order. So enforcement is more so a civil procedure. It's a form of civil procedure whereby you have a few options of enforcement, one of which would include garnishee proceedings, which I think is what you're trying to get to here with the employer's bank account. You can't just directly access your employer's bank account. You need to apply to the court. If you, for example, you know your employer's bank account number, and you can get an order from the court to essentially compel the bank to freeze the employer's bank accounts until they pay the outstanding wages owed to you. I hope that answers your question.
Thank you, Kritika. Also, we do have several questions, but I believe we have run out of time. But worry not, because if you have any further questions, we do offer a complimentary 30-minute consultation, details which will be given later. So before we conclude, I have several announcements to make. Firstly, please do join us again for our upcoming talks. Our next talk will be on the 7th of June 2023 on navigating divorce obligations, insights on varying and enforcing Decree 9 orders. The speakers will be Ms. Rachel Ng and Kritika Padmanabhan. You can also scan the QR code on the screen to sign up for more of our online talks. Secondly, do follow and like our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. As you can see, the links provided on the screen. Next, if you would like to speak with our lawyers, we do offer a complimentary 30-minute consultation over the telephone or over a video conference. Please fill in the form on our website or scan the QR code on the screen. So that will be all for today. To our guests, thank you for joining us. We hope you have found today's session informative and useful.